In Pakistan we here now are lacking a regional instrument, a human rights treaty. What the others are in Europe, we have the European Convention on Human Rights, which was ratified by the UK in 1951. Looking around the world a little, we've got the African Charter on Human and People's Rights. That, for the historians amongst you, was 1981. And we also have the Arab Charter on Human Rights and the American Convention on Human Rights. So there's a big lack of a regional human rights treaty here. Now, what's the point of them? What's the philosophy behind them? Well, basically the reason is that the regional instruments are meant to convey a message that international human rights or human rights of people within states should not simply be a matter for the UN, for the United Nations, but rather there should be responsibility of individual states. So that's why we have the regional mechanisms. A little bit about the European Convention. Some of you may be familiar, others not. But many of the rights within the European Convention and protections you will find reflected in Pakistan's constitution, and also in the International Covenant of Civil and Political Rights, which is a treaty that Pakistan has ratified. Now, that was drafted by conservative jurists, our Tory party, and it was supported at the time by Winston Churchill. There's a right of individual petition. That means the individual can go and complain that their rights have been breached. They don't have to rely on the state bringing a complaint on their behalf. And that came in 1966, so it's been around a long time. Now, the UK has a dualist system, like many countries in the Commonwealth who inherit UK from the laws from the colonial times. And what that means is that domestic law is required for international law to be directly enforceable. So within the UK, we got the Human Rights Act, which was a creature of the Labour Party, which came in, well, it was passed into legislation in 1998. The idea of the Human Rights Act was to bring human rights home. So instead of us all going off to Strasbourg, where the European Court is, we could make these complaints within our own domestic courts and bring the complaints of breaches of international human rights within our local courts. So the European Court of Human Rights, I'm going to just move on to the political situation. It's come under a lot of criticism within the UK. And one of the criticisms has been we have a foreign court overreaching into our own sovereignty. We have good laws ourselves. Why do we need a foreign court? But of course it's not a foreign court. It was one which has gone through parliament processes, legislation has come in, and it is part of the domestic system within the UK, and there's representatives from different countries who sit, including the UK, who sit on the European Court. As to what account the Human Rights Act brings into legislation, what power it has, well, what is important is our parliamentarians have to take account of it when they're bringing in legislation. And our courts have to interpret legislation so that it's compatible with convention rights. So why has there been criticism? Well, there was one case called Abu Qatada, and he'd been in the UK for a long time, and he was a fairly extremist Islamist preacher, and he really had a look of an evil comic book character. He had a hook in place of his hand had been blown off by a bomb many years previously, and he would come out with very extreme language. However, insufficient to charge him with a criminal offence. He was detained under the UK's terrorism acts at various points, but without charge. Now, the controversy was that there was an application from Jordan to extradite him, to try him for terrorist offences in Jordan. And there was a series of cases brought on behalf of Abu Qatada, which were successful, saying basically we cannot extradite Abu Qatada to Jordan because the evidence that's going to be used there was obtained by torture. And under the Convention Against Torture, which applies equally here, by the way, people should not be tried on evidence that has been obtained by torture. The way around this was that there was an agreement between Jordan and the UK that the evidence obtained by torture would not be used in his case, and he was extradited. But a lot of anger was directed at the Human Rights Act. It was said it was the Human Rights Act which was preventing his extradition. The arguments were made under the Human Rights Act, but in fact, arguments under other treaties, such as the Convention Against Torture, would have had the same effect. So the international treaties are there, and of course should not act against them. So that was one of the ones that caused a lot of upset. Now, just moving on from, I'm just going to skip through so it's not too legal, but there's often confusion as well, if I can just make this point, with the European Convention and the EU and Brexit, and see the two things as different. However, there has been a pledge by our Prime Minister, Theresa May, that she is going to fight the 2020 election on the basis that we are going to withdraw from the European Convention on Human Rights. This would be a real backward step. It would be a backward step for the UK, but it also will be a backward step internationally. And I'm just going to point to what happens and how we now really are such a small world, how the actions of one country affects another. Shortly after there were attacks upon the Human Rights Act and upon the European Court, in particular it was all happening around 2014. Shortly after this was all trailed in the press, Ukraine refused to follow an order of the European Court to reinstate a judge of its Supreme Court. At the time also, there was an international warrant from the ICC against President Kenyatta of Kenya. And he took support from the political attacks within the UK to make his own attacks on international law, on the international human rights system. So it does have a far-reaching effect. The bigger picture is always crucial and is always essential. The bottom line, however, is that the common law in Europe, so looking at the UK, within Europe, the common law has developed so much over the decades that it will remain applicable regardless of the Human Rights Act. But I'm just really going to conclude with a little reflection back to that Nuremberg trial and what happened there when the case was opened against the Nazi leaders and the prosecution of them at the Nuremberg trial. And it was former Justice Jackson who said this. He was then brought in to prosecute. And this is what he said. He said that 4 great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. Thank you very much.